I'm Benedicta van Minden, the chair of this meeting. Hoping everyone is here. I think we can start. It's 2 o'clock. So I really want to welcome everyone here. So thank you very much for coming. Let me just turn my camera on briefly so that you can see it. It is indeed me. Thank you very much, everyone, for being here on a Friday afternoon. We actually have a whole number of people, including a number of visitors. So I really want to welcome our committee members who are here, our permanent delegate in the NCOP, Mr. Rikus Badenhorst. I think we also have another member of our NCOP members here. And then obviously a particular welcome to the Honorary Deputy Minister, Pinky Kekana, as well as officials from the Department of Public Service and Administration, Ms. Yuliswa Makazi, Ms. Renisha Naidu, and Ms. Amukelani Baloy. I think before we all kick off, let us all introduce ourselves, starting with the committee. And then from there, I think everyone else can then introduce themselves. So I am Benedicta van Minden. I am the chair of this committee.
Afternoon, Dave Bryant, member of the committee.
Good afternoon, Leon van Wyk, member of the committee.
Good afternoon, Khalid Sayed, member of this committee. Thank you.
Good afternoon, Pat Lecker, an alternate member of this committee. Thank you.
Good afternoon, Chairperson and members and all guests. My name is Wendy Kaiser-Philander and I'm a member of this committee.
Good afternoon, Brett Heron, member of the committee.
Good afternoon, Chair and all members. And I'm Donita Stevens and I'm a member of this committee.
I think that's everyone from the committee. So I think let's start with the Honourable Kekana and then we can go on to the officials.
Thank you, honourable members. My name is Pinky Kekana, the Deputy Minister of the Department of Public Service and Administration. Renisha, can you please introduce your team?
Apologies, DM. I managed to join, but my network is not in a very good state. Good morning, good day, honourable members. My name is Yoli Somakasi. I'm the DG DPSA.
Who else is there from the department, DG?
Thank you, DM. Renisha, please introduce yourself and Amu. Renisha? She was connected earlier on. Let me check them.
I'm also here, Deputy Minister, on behalf of the Minister. Thank you, Dr. Ntabiseng Molefe.
Good afternoon. I'm Amukelani Baloyi from the DPSA. I see Ms. Naidu is being kicked out of the meeting. I tried to admit her. I'll just check if she has problems with her connections. Thank you.
Thanks.
Thank you, Amu. Good afternoon, colleagues. Good afternoon, Chair. Good afternoon, DG and colleagues. My name is Renisha Naidu, and I'm the Chief Director, Legal Services in the Department of Public Service and Administration. Thank you.
Okay, then our members from the NCOP.
Hi, good afternoon. Rikus Badenhorst, Permanent Delegate Western Cape, member of the Proctor Committee, where this bill is going to go through in the NCOP. Thank you.
Right, thanks. I think that is everybody. If I have missed anyone, please just shout. Okay, so in terms of the meeting this afternoon, it is obviously to brief the committee by the permanent delegates and the Department of Public Service and Administration on the Public Administration Management Amendment Act and the Public Service Amendment Bill. Just to lay some ground rules. So everyone is muted at the beginning of the meeting. So just be aware that if you need to talk, to raise your hand, and then you'll obviously need to unmute. If you want to flag points of order, please use the chat function in the MS Teams. Obviously, all video to be turned off. I think there's quite a lot of us here and we don't want to strain the bandwidth. And then once you finish speaking, if you can just turn your mic off again, please. As I said, thank you all very much for being here. I'm going to hand over now to the permanent delegates, the Deputy Minister and the DG to please make introductory remarks before we then have the presentation. Who would like to kick off?
Chair, thank you very much, Sneh. I want to really apologize to the members. I'm in Tabazimbi. Members of the NCOP know that the municipality has been dissolved, so we're doing door-to-door here. That's why there's noise in the background. And I will also want to apologize so that after my presentation, the team can, through the DG, take the process forward. We really appreciate your availability, including members of the NCOP. This is the second province we're engaging with. We were in the Northwest just a few days ago. Chair, we're dealing with two bills, one being the Public Service Amendment Bill and the other one being the Public Administration Management Bill. And already, like we said, the bills are at your doorsteps. One, to enable the public service and government to function optimally in a single public administration to provide the best possible service to the citizens. You have seen the challenges that our communities are going through. We want to up the game as the DPSC. And we also want to create an enabling environment that ensures that our public service is professionalized and that the public servants uphold the values and principles enshrined in our constitution. So whether government is there, whether the political office is there, or we're going to elections or whatever, administration must still continue to run. So, and then the third one is ultimately that the words building a capable, professional and ethical state are translated into action. You will remember that in the GNU, there are three priorities, and one of those priorities is precisely to deal with building a capable state, which is professional, which is also ethical. So these bills are looking at some of these things. We really want to appreciate what the province has done, and we hope we are going to have positive engagements, and we are going to be there to really fast track some of these things to enable government to run accordingly. I want to hand over to our DG and her team to take the committee through. I really want to apologize once more, Chair. I'm in Tabazimbi, and but I'll get feedback accordingly. Thank you very much.
Much, and we really do appreciate you being here. I also understand that the minister unfortunately had to send his apologies, which we've noted. And yes, I think if I may just ask the permanent delegate to make the opening remarks, and then we can hand over to the DG. Honourable Badenhorst.
I'll let Honourable Skeerkoorl go. He takes the lead on this in the Cocta committee.
Okay, great. Honourable member.
Just hold on, sorry. Open the right document. Please. Thank you. Sorry for that. I was just going through. So, the intention of this act is just to establish a single piece of legislation which will govern the public administration. So, however, this goal has never really realized through the Principal Act because it failed repeal the public service tax as well as the Municipal Act. So, in addition to the 7 remaining sections of the Act that's inoperative, so it will still require some regulations and then further amendments, which will difficult to be implemented. But so that we want to ensure that this Act, when both of them are implemented, that we have a public service that's working for us. And as the DM has said, that we, when political when there's change within the political leadership, that public administration goes on. So the various clauses that are there are 3, 5, 6, 9, 11, 14, 14b. So, but then, yes, basically it comes down to that we need to make sure that we have a public administration that is professional, and to ensure that when there's transfer of power, that our citizens, our residents don't fall behind. So after that, citizens can go to the administration to go into further details so that the members can ask their questions to the administration.
So you aren't that clear. We can make out what you're saying, but there does appear to be a bit of background noise. If I could then hand over to the DG, please.
Thank you, Madam Chair. I have a colleague from DPSA, Renisha. She's going to be taking you through the presentation. She's our head of legal, and she's also accompanied by Amu, who is also our colleague in the legal team. They are going to take you through the presentation. Chair, I do want to apologize. I don't have a good network where I am, so if I'm cutting a little bit, I apologize for that. I don't know how long it can carry me. Thank you.
Thank you very much. Okay, let's go on to the presentation.
Thank you, Chair. I'm going to request through the DG and through the Chair that my colleague Ms. Beloy starts with the Public Service Amendment Bill, and then I will take over from the Public Administration Management Amendment Bill. Amo, if you can flight your presentation. Chair, I'm not sure if I don't have access to share. I'm not sure if Amo has been given access to share.
You know, I also don't have access to share.
Let me just ask our procedural officer, Ms. Kamish Ahmad, if she can just facilitate what needs to be done there.
Thank you so much.
I've just given permission to all presenters. They can just check again. If not, then I'll just slide the presentation. If they can just guide me as to what they want first. It's the amendment bill.
It's the Public Service Amendment Bill, please, my dear. Yes. Thank you. Sorry, we still don't have rights to share. Thanks.
Okay, I'm seeing it. Has everyone else got that in front of them?
I can see it.
Okay, great. Right, over to you.
Thank you. Good afternoon, Chair, members of the committee, DG, and ladies and gentlemen. My name is Amkelani Baloyi. I'll be taking you through our presentation on the Public Service Amendment Bill. We started this process to amend both the Public Service Act and the Public Administration Management Act in 2014. And the thinking behind the amendment in the bills is to basically cover 4 important areas, which first look at the citizens. And the question we ask is, how would citizens benefit from the public administration? The second area we're trying to cover is, how does the government meet its obligation to the citizens of South Africa? We also focus on service delivery. Sorry, Chair, there is somebody who is speaking.
Let me just deal with that. Thanks very much. Mr. Mapela, if you can just make sure that you're muted. I think we're fine now. Thanks.
Thank you, Chair. We also look at the services that we deliver as government and how we deliver these services to ensure that we fulfill our obligations. We look at the employees in the public administration, and the question we're asking here is what is expected from public servants to ensure that the services that we are supposed to deliver are rendered properly. The amendments that we are going to be speaking to, Chair and members, are mainly informed by the National Development Plan. We are also guided by recent changes in labor legislation and policies. We are looking at the objective of creating a single public administration. We're guided by the professionalization framework, and we're also responding to the President's plan after the Zondo Commission report. Next slide, please. In terms of the processes that we have followed, Chair, up to this point, both bills were running concurrently, so these dates will cover both the Public Service Amendment Bill and the Public Administration Management Bill. On the 6th of April 2021, we published these bills for public comments, and during this period, we received extensive comments from the public, which we dealt with. We also took the bills through the consultation processes at the Bargaining Council. We spent almost a year there. So we started in April 2021 and the processes were concluded in July 2022. We then moved into NETLEG and we concluded the processes in NETLEG on the 23rd of February in 2023. We submitted the bills to Parliament in March 2023 and we went through the select committee in Parliament. Certain changes were made to both bills. As we present, we will highlight them. Two were made to the Public Service Amendment Bill, and some changes were made to the PAMA Bill, which Ms. Naidu will speak to. The bills were then referred to the National Assembly on the 14th of February 2022. On the 27th of February, they were adopted by the National Assembly and then referred to the Select Committee in the NCOP, and that is where the bills are currently. I'm now going to deal with each proposed amendment per clause. In the first clause, Chair and members, we are proposing amendments to the definition of executive authority. And the reason for this proposal is we are clarifying the powers of the President and the Premier in relation to heads of departments and the management of their appointments and career incidents. We are amending the definition of head of department, and this is for ease of interpretation. The one big thing that we're doing here is we are removing reference to acting HODs, as it is not necessary for us to refer to those. And it has also caused confusion, so we just want to clarify that. We are proposing an additional definition, Chair, to the definitions. And here we are proposing an insertion of a definition for political office. When I get to clause 15 of the bill, Chair, I will speak to the prohibition that we are building in the bill to prohibit heads of departments and employees who report directly to heads of departments from holding political office. And for purposes of that clause, it is important that we define political office. Political office has been defined as the position of chairperson, deputy chairperson, secretary, deputy secretary, and treasury. We have also tried to cover instances where these positions are not named as such in a political party. Can I please get the next slide, please? Okay. One of the proposed amendments to the Public Service Act, Chair and members, is informed by the NDP, as I have mentioned in the first slide. And what the NDP has done is it has identified certain political administrative interfaces and the tension that occurs. And as a solution, the NDP has proposed the devolution of powers from executive authorities to heads of departments. In particular, this is the devolution of administrative powers. So we have drafted the bill to give effect to this proposal by the NDP. The next slide, please. Okay. Here, Chair, what we have done to give effect to this proposal by the NDP is we are proposing rather that we leave strategic powers with executive authorities, and we vest administrative powers with heads of departments. And it is envisaged that once that is done, then it will assist executive authorities in that it will unburden them from dealing with day-to-day administrative matters. They will be more focused on strategic matters and their constitutional obligations. Decision-making will be easier when it's closer to administration, which is on the DG level. In terms of the PFMA, the DG has financial responsibilities, and it is envisaged that once they are responsible for HR responsibilities, which are in the Public Service Act, then they will be better placed to run departments. I spoke to the tension and conflict that rises, which was identified by the NDP, and it is envisaged that this proposed amendment will deal with that. And ultimately, Chair, the DGs are accountable for the output of the department, so they would be better placed to hold administrative powers. Here, Chair, we are just giving a picture of what the proposal will look at should we be able to vest administrative powers with heads of departments. On the left-hand side of the, yes, thank you. On the left-hand side, Chair, we are outlining the provisions of the Constitution. So in terms of the Constitution, we have the executive, which is made out of the president and premiers, ministers and MECs, as well as deputy ministers. And here we are just highlighting that they have powers in terms of the Constitution, which will not be affected by this proposal of devolving administrative powers in terms of the Public Service Act to heads of department. So ministers, MECs, the president and premiers and deputy ministers will retain their powers in terms of the Constitution. On the right side of the table, we are showing the administration, and here we're highlighting that in the administration, we have the president, the executive authority, heads of departments, SMS members, and non-SMSs. The powers that are in dark blue are powers that DGs currently have in terms of the Public Service Act. So that is the powers for discipline management, labor relations, and utilization and training of staff. They retain that. And those that are highlighted in light blue, those are the powers that we are proposing should be vested from EAs. So currently these powers are vested with EAs, and we are proposing that the powers for performance management, remuneration, recruitment, dismissal, transfers, HR planning, and organizational structure and establishment, as well as approving of RWAPs, should be devolved with DGs. And in the red, we are showing that the executive authorities will continue to approve the strategic plans of the departments. So our bill, Chair, at section 37, so it's section 37 of the Act, we then amended the section to give powers to the executive authority to be accountable for the functional areas of their departments, to be responsible for approving the department, the strategic plans of the department, to ensure that the heads of department fulfill Chair, that the roles and responsibilities of HODs are aligned with the strategic plan. EAs are also expected to establish clear relationships between the DG and employees in the department, and executive authorities should hold the DGs accountable for running the department and also exercise any powers that are conferred on them by the Act. Currently, Chair, the administrative powers, as I've explained, lie with EAs, and they can be delegated to DGs. But because here we're proposing that they should be vested with DGs, it is important that we have checks and balances in place to ensure that executive authorities are able to manage DGs to a certain extent. So what currently happens is, if a DG has delegations over administrative powers, they can be withdrawn and because we are taking that away, we had to build in checks and balances. So the checks and balances that we have built in is that the DGs would be accountable to the EA. DGs must report to the EA when they are required to, and DGs must assist EAs in fulfilling their executive authorities. We've also built in a new provision where we have made provision for instances where an executive authority should intervene and take steps when a DG fails to fulfill their responsibilities. In the first slide or so, Chair, I mentioned that during our consultation in the National Assembly, changes were made to the bill. So one of the changes that were made to the Public Service Amendment Bill is when we went into the National Assembly, this provision for the EA to intervene, it made reference to the fact that the executive authority may intervene. And during these processes, there was suggestion that we must rewrite the provision to say the executive authorities must intervene so that we don't give the executive a discretion to intervene or not. So that is one of the changes that were made. Here, Chair, I spoke to these powers that we are proposing that they should be vested with the HODs. They currently vest with EAs. And the proposal now is that they should be vested with HODs. So in the table, I spoke to these, but here what we are trying to show is the clauses in the bill which would be affected by the proposal of the devolution of powers. I think we can move to the next slide. Thank you. Chair, one of the other proposals of the NDP is the creation of a head of public service. We have given effect to this proposal by amending section 730C of the Public Service Act. And here what we are doing is we're giving additional powers to the DG in the presidency to be secretariat to cabinet, to coordinate and convene and chair the FOSAT, to be responsible for intergovernmental relations, to support the president and to perform any functions and duties that are imposed on them, or if they are so requested by the president, subject to the constitution or any other law. The NDP also proposes that a similar provision should exist for DGs in the office of the Premier, but it was not necessary for us to make an amendment for this, as currently in the Public Service Act, we already have a provision for the DG in the office of the Premier. The next few slides, Chair, I'll just be taking you and the members through the technical amendments that we needed to do in the bill. The first will be reflected at clause 8, and here we are amending section 15.1, or rather we are proposing that we retain section 15.1 of the Act. So, Chair and members, the Public Administration Management Act repeals section 15 of the Public Service Act, which deals with secondments. Section 15.1 of the Public Service Act makes provision for employees who are seconded into the public service from organs of state to continue to retain certain benefits. Because the entire section 15 will be repealed by PAMA, we still need this section to exist in the Public Service Act. So we are proposing that it should be retained, but we will only retain section 15.1. At clause 9, we are proposing an amendment to section 16. So previously, the Public Service Act made reference to officer, and the Act was amended to substitute reference to officer with employee. A mistake happened and one part of the Act was missed, which is still referring to officer instead of employee. So we are cleaning that up. At clause 13, we are amending section 31, and here we are just correcting reference to the Commission, the Constitution, and section 30. We have a proposed amendment to section 32 at clause 14. So clause 14 makes provision for reassignments and acting appointments, and we are cleaning up this provision. It currently exists. We are just writing it to Benita. And what we are doing for purposes of reassignments is we are only permitting reassignments within the department, and the power to reassign an executive authority will lie, pardon me, the power to reassign an HOD will lie with an executive authority, and the power to reassign any other employee will lie with the HOD. In terms of acting arrangements, we are limiting acting only within the department. Any employee who occupies the post would appoint somebody to act in their absence. And when there is a vacant HOD post in the department, the relevant executive authority responsible for that portfolio can appoint a person to act in that vacant post. However, they would have to consult the president or the premier. Where there is a vacant post within the department, which is not an HOD post, then it is the HOD who would be responsible to appoint persons to act. And just to add, Chair, the nitty-gritties and the process and period of acting would be regulated in the public service regulations. What we are doing here is we are just giving the power in the act to appoint, but in terms of how you do it and for how long you do it, all of that would be regulated in the public service regulation. At clause 15, we're proposing an amendment to section 35, which deals with grievance procedures. And here we are just clarifying that for purposes of internal grievance processes, the power to determine the rules for those processes lies with the Minister for the Public Service and Administration, and the power to determine rules to refer grievance procedures to the PSC would lie with the PSC. So we are just clarifying that the Minister is responsible for determining rules for internal processes for grievances, which is part of the collective agreement, while the PSC is responsible for the rules for their procedure. When I dealt with the definition, Chair, I mentioned that we are proposing an insertion at section 36A, where we are proposing that heads of departments and employees reporting directly to them should be prohibited from holding political office as defined in the definition section. In terms of section 19 of the Constitution, everyone has the right to have political rights, which include participating in activities of a political party. However, because we are trying to manage conflict of interest between political parties and the administration, and to ensure that there's a clear demarcation of politics from administrative roles and responsibilities, we're proposing that we limit this right for DGs and employees who report directly to them. When we consulted the bill's chair and members, we did not have this provision in its current form. So initially we had proposed that all employees should be limited from holding political rights, but you will see, Chair and members, that section 36 of the Constitution requires that you justify any limitation to a right. And when we needed to apply this section to justify our limitation on this right, we could not justify why we want to spread the limitation across the board. So we could only justify it being limited to heads of department and employees reporting directly to them because of their level of decision making in the departments. At clause 18 of the bill, Chair, we're proposing an amendment to section 38 2B1. This provision was declared unconstitutional by the Constitutional Court. It sometimes happens, Chair and members, that overpayments are erroneously made to employees, and this error has to be fixed by recovering the overpayment. So the Constitutional Court declared this provision unconstitutional on the basis that we did not have a process to follow when we recovered the overpaid amount. We were instructed by the Constitutional Court to align this provision with the Basic Conditions of Employment Act, which basically sets parameters in terms of the amount that you can recover, and it builds in processes and it sets mechanisms in place to ensure that you protect the rights of employees when you recover overpaid salaries. So how it looks now in the bill is that when you recover overpaid remuneration from employees, you can only do it with the written consent. In the event that employees do not give you consent for the recovery, then you need to follow legal proceedings. We have built in place a process to follow when the employee has moved departments. We've also built in place a process to follow when an employee is no longer in the employ of the state. Chair, we have had concerns in terms of how we manage consequences, because in most instances when this overpayment takes place, the employee who's affected would not have been responsible for the overpayment itself. Because of the legal principle of unjustified enrichment, Chair, it is important for us as the employer to be able to recover overpaid monies, which were erroneously made.
Sorry, can you just hold on a moment? Everyone, can we just make sure we muted? Mr. Mushi, can you just make sure that you're muted? Thank you. Okay. All right, let's proceed.
Thank you, Chair. So we have a legal principle of unjustified enrichment. So while we recognize that the employee who would have been affected by the overpayment would not be responsible for the overpayment, we need to be able to recover state money whenever it is overpaid to an employee. We have provisions where we deal with discipline in instances where an employee was negligent in the overpayment. What is also important to mention for purposes of the slide, Chair, is heads of departments as accounting officers in terms of the PFMA and the Public Service Act also have powers to write off debts where it is justifiable. Pardon me, Chair. Thank you. Where it is justifiable for them to write off those debts. So we have all those provisions in place, and it is important that we mention them. The next slide, please. The next and final amendment that we proposing, Chair and members, is at clause 19, where we deal with delegations. And here we're proposing an amendment to section 42A. Currently, section 42A gives the president powers to delegate matters relating to the appointment and career incidents of heads of departments to the deputy president and minister. Minister is defined in terms of the Public Service Act as the Minister for Public Service Act and Administration. But the intention of this provision is for the president to be able to delegate these powers to the deputy president and any minister. So we are removing reference to deputy president and minister, and we are replacing that with a member of cabinet. Okay, this next clause deals with short title and commencement. And yes, that is the end of my presentation, Chair and members. Thank you.
Thank you very much. I just want to find out if there are any questions at this point. If I could please see hands. I've got Honorable Syed. Okay, let's start with you, Honorable Syed, and then let's see if the other hands have come up. Thanks.
Thank you very much, Chairperson, and thank you to the officials for the presentation. The only issue that I just wanted some clarity around is when it comes to the issues, the changes being made, particularly with regards to staffing issues and the role of the HOD vis-a-vis the Chief of Staffs. I just wanted to know what impact does this then have on the ministry staff, because you get your ministry staff in the political office. For example, a question that I could look at having, is just, will ministry staff, what will then be, will ministry staff be assessed? Will their performances, for example, even what they need to do, be determined by the DGs and the heads of departments? Or are they still going to be accountable to the deputy ministers and the ministers? And how does that, how do the officials, how does the department see this playing itself out at a very practical level? I give you an example. You find many cases, both in provinces as well as at national level, where staff members who are working in the ministries per se would be, for example, reporting to the political principal or to the chief of staff, and they're doing the work that they ought to do in the office as set out by the political principals. But then they're not necessarily ticking the boxes and doing what's expected from the department per se. And then you often find, some bit of a conflict taking place in that regard. On the other end, sometimes you've got cases where there's, because of the political nature of things, there's a fallout between a staff member in a political office and the political principal wants to see the staff member go. They don't really have valid grounds in terms of the human resource aspect or the public service aspect. But then it also creates another breakdown because, from the side of the public service or from the side of the department, they would say, no, that the staff member is performing. So I just wanted to get a sense as to how do we deal with those situations within this particular context? And is there a distinction being drawn between the staff in the political office and the staff in the department? Thank you.
Can we just get a response there? Ms. Naidu?
Thank you so much, Chair. Maybe if I can try answering Honourable Member Said. Currently, the way organizational structures are configured, all structures below or all employees within the organization, whether they fall in the office of the minister, whether they fall in the office of the DG or in relevant units within the organization, all of those staff report organizationally to a HOD. The HOD then in response reports to a minister or a deputy minister or an EA. So the appointment processes that we are envisaging are those that will allow the HOD to appoint all members of the organization, so all employees within the organization, including those members of staff in the offices of ministers and EAs. Currently, the situation is pretty much the same, except that the appointment processes are done by ministers. In most departments, these responsibilities are delegated currently. In some, they're not so. But ultimately, in terms of an organizational perspective, performance of those officials is managed within the organization. Any fallout that happens between ministers and their staff follows the same processes as any other employee rights that are envisaged on other employees. So the ministry staff don't have a different dispensation in terms of employment rights. They all are public servants and they'll follow the same prescripts. I hope I've answered. Thank you so much.
Thank you very much. Honourable Bryant?
Thanks very much, Chairperson. I think my question follows on from Honourable Syed, and I think maybe his answered. So I'm just going to lead on to where I think maybe one was going with that. For instance, in a political office bearer's office itself, a minister, MEC, etc. if for instance, a minister wants to have a personal secretary or a chief of staff in their office, and the department then comes back and says, this is the person who's going to be your secretary, or this is the person who's going to be your chief of staff, would the minister then be compelled to accept that person? Would they have no say over the selection process? Would that all be conducted independently? I'm just thinking about potential incongruity between certain political office bearers and someone who's working with very sensitive information in their office, for instance.
That's a very solid question. If we can just get someone to respond to that.
Chair, I'm accompanied by my colleagues, so if they feel they want to step in, they must please do so. Honourable Member, I think when we drafted the public service regulations, and we must remember that once this bill is passed into law, we will need to then amend those public service regulations. But currently the practice is that members of the executive can, without following an open advertisement process, nominate people for appointment in their offices. And we don't envisage that process will change. What we are saying is the appointment itself will be done by HODs, and we will manage it through proper regulations that will allow it. Because the current process of not going through an open advertisement process is configured through the public service regulations, not the Act itself. Thanks.
Thanks very much. Are there any follow-ups to that or any new questions? I'm not seeing any more hands. Okay, there we go. Honourable Said.
Chair, thank you very much. I think the Honourable Bryant raises a very, very important question. So I just wanted to get it clear then. So the line that we are moving towards, because then that would be, I would say now, that would be a concern, at least for myself. The line that, if it is true, I just wanted to get a sense of the line that are we moving towards a line that is going to become similar to the situation in the UK, where ministers and deputy ministers are not necessarily able to appoint their own or to determine whom they want as the staff in their offices? I just wanted to get a sense of that, or whether that is in the pipeline, or is that not on the table? Thank you.
And then I've also got a question from Honourable Heron. I think let's just have that one now, and then we can answer both at the same time. Honourable Heron.
Thanks, Chair. I think maybe I'm anticipating the answer, because I thought, just in response to Honourable Said's follow-up, that we were just told that the practice of political executives, so ministers and MECs, of being able to appoint staff in their office without following a competitive process is likely to continue. I think that's what we were just told. But I wanted to just add a question to that and just confirm that, in fact, that the political appointments in ministers and MEC, in ministers' offices anyway, already fall under, from an administrative perspective, the Director General's authority of those departments. So for HR purposes and leave purposes and etc., they sort of report administratively to the Director General, and also that there are standards, for want of a better word, or requirements, is a better word, requirements for the appointment of those staff members. So although political executives can make appointments without following a competitive process, and that, as I think we were told, that's not going to change, those appointees need to meet requirements that are already determined by the Minister of Public Service and Administration. Thanks.
Thanks. If we just get a response to those two questions, which are, connected.
Thank you so much, Chair. Honorable Heron is quite correct. What we have done in the public service regulations that has become the practice is that we have recognized that when it comes to certain positions in offices of the executive, there is a need to have a certain level of trust and a certain level of requirements of people to be in those positions. And for that reason, we have been able to justify why we don't go out on a normal recruitment drive to fill those positions. What we also do in the regulations is that we limit, because we don't bring people in to those offices through a recruitment process, we also then limit the period of their employment. So they are only employed for as long as that member of the executive is in that office. So those have been the parameters, and those parameters will not change because the circumstances are unlikely to change. However, I do think that the point raised is important, and it's something that we will look at when we draft the regulations, so that we build in a process that will allow a consultative process with the member of the executive before any appointment is made by the HOD. But the provisions as we are proposing is that all appointments in the public service should be done by HODs and no longer by members of the executive. Thanks.
Yeah, thank you very much. Are there any follow-ups on that or any other questions? Not seeing any other hands. So I'm going to assume that everyone is at this point happy with the briefing and the answers that we've received. What I am going to do now is ask our members in the NCOP. Oh, is this the, yes, this is the next one. Was this the presentation we've just had, or is this the other amendments that we've got in front of us? Okay, all right. I'm going to ask our members. Yes.
My apologies, Chair. This is the second presentation that's being flighted.
Great, let's go ahead with that. I can hand over to you.
Okay, thank you very much. Again, Chair, thank you very much for the opportunity to present. My name is Renisha Naidu, and I've been dealing with this particular amendment. If we can move to the next slide, please. Chair, the context of this bill was similar to in terms of the start date when we started the public service amendment as well. So we ran both processes parallel. Most of the processes took place at the same time, so the dates coincide. We also looked at all of the different areas that were presented in the previous presentation, so I'm not going to go too much into that. But ultimately, this bill is different from the previous bill that was presented, or the previous act, is that this is one of those acts that traverse all three spheres of government. So this is an act where the scope includes the public service, which is your national and provincial departments, but it also includes local government in terms of your municipalities. So as we drafted this bill and as we contextualize this bill, I think it's important to recognize the different spheres of government and the different constitutional responsibilities. So we had to tread carefully to ensure that we don't encroach on any other sphere of government. The idea of this bill, Chair, was to create harmony between the three spheres of government. And to some extent in this amendment, we've taken it into the public entities, and I'll explain where that is. But ultimately, our focus was to try and coordinate our government in terms of three spheres to ensure that we have an effective and efficient public administration. We also looked at the existing legislation, and we ensured that we were not replicating existing legislation, and that whatever we were putting in front of Parliament was to ensure that we were meeting the obligations of Section 197 and 195 of the Constitution. The main goal of this bill is to ensure that the state has capacity throughout the administration. And when we talk about a state capacity, we're talking about the necessary skills and attributes of employees. And we're also looking at the capability. So when you look at the whole of the Act, the Principal Act, including the amendments, these are the areas that you will find focus on this particular piece of legislation. If we can move to the next slide. Chair, in terms of this particular bill, initially when this bill was drafted in 2014 and processed in 2014, it was envisaged to be the legislation that will give us a single public administration. So the initiative was driven through this particular bill. The intention initially was to have one piece of law that will regulate all of government. So we would not then need a Public Service Act, we would not then need a Municipal Systems Act or a Municipal Structures Act. But what we have done over time is that we've realized that there are pieces of legislation that operate and function properly. And what we have focused and rediverted our energies when it comes to the Public Administration Management Act is to look at those provisions that don't exist in government across the three spheres of government, as well as to look at areas where there needs to be a single piece of legislation that deals with particular areas. So you will find as we delve into the legislation, it talks to areas that are not regulated elsewhere. And where there are acts that exist across the public administration in different areas, we have tried to, as government, to look at regulations and processes that then streamline and talk to each other so that when we draft regulations, we also ensure that there's better coordination between our regulations that will allow us to achieve a single public administration within the current legislative framework. So the idea is not then to repeal any legislation that currently exists in its entire form, but to rather streamline, as I've said. When we look at this piece of legislation, the amendments are seeking to introduce new aspects into the framework which are not regulated elsewhere. And these are some of these, and I'll talk to them in detail, is to look at where there are unjustified disparities across government, including public entities, to focus on a sustainable fiscal framework, to ensure that we coordinate in terms of remuneration and conditions of service. We've seen in the past that there are huge disparities between how employees are paid in different spheres of government, different institutions. So the idea is that we should start to streamline these processes. And then most importantly is to ensure that wherever we need human resources, we are able to have people employed and moved around the public administration in a manner that doesn't disadvantage employees. If we can move to the next slide, please. So Chair, I'm going to jump this slide. There's just a typo on the slide that talks to the changes. In the National Assembly, there were 5 changes that were made, and I'll talk to them as we go into the slides. But the processes and the dates, again, are very similar to what Amu has already presented. So I'm going to jump this. Thank you. Chair, in terms of the definitions, one of the things that the Principal Act didn't do properly was that it didn't define concepts. So it used concepts like head of institution, the Labor Relations Act, organized local government, but there was no definitions for it. What we have then done is we have provided definitions so that there's ease of interpretation. Currently, we were unable to bring some of the sections into operation because we didn't have these definitions. So the idea is to clarify and define. In terms of clause 2, it deals with individual transfers. There is a provision within the Principal Act that allows for employees to transfer across government. So from local government to municipalities, from local government to the public service, which includes national and provincial, and vice versa, and even between municipalities. The difficulty in the implementation of the current processes is that one of the things that this provision does in the Public Administration Management Act is that it repeals Section 14 of the Public Service Act. And that creates in its own difficulties in implementation, because there are provisions within the Public Service Act that then become difficult to manage. So we have not, since 2014, brought this particular provision of the PALMA into operation, and we are proposing an amendment to make it implementable. And the amendment we are proposing, Chair, is that the Public Service Act provisions should remain as they currently are. So the repeal of Section 14 should be undone and reenacted. And that's part of the provisions that are being proposed in this bill. And what that will do, it will allow the Public Service Act, Section 14, to remain the authority on which public servants transfer within the public service. Additionally, what this bill does is that it seeks to deal with the situation where we currently don't have a law other than the Public Administration Management Act to transfer people between the public service and local government, or even between municipalities themselves. So what the provision is going to do and what it seeks to do is to allow employees from a municipality to transfer to a public service department, which is your national or provincial department, or vice versa, without any changes in their terms and conditions and without affecting or adversely affecting employees. But as we do that, Chair, I think what's important is to understand that as we do this amendment, we are not changing the fundamental principles that are currently in the Act, which is that employees who are being transferred must be able to perform the duties to the post of the position to which they are being transferred. So they must have the necessary skills and competence. They must be transferred because there's possible implications on conditions of service, because we know between local government and the public service, there are differences in conditions of service. There are different medical aids, there are different pension funds, etc. So one of the provisions is that when you transfer across local government and the public service, you must get the consent of that particular employee. The idea with transfers, Chair, it's important for the public administration to function because this allows employees to move across. It's an enabler to allow someone from the public service to be transferred without changes in terms and conditions to another sphere of government. And I think that's the most important part of this particular provision. But as we did that, like I said, we attempted not to adversely affect employees. We can have the next slide, please. Chair, in terms of secondments, there is a provision in the Principal Act that talks to secondments, and it allows the secondment of employees across 3 spheres of government. We are retaining that provision. However, we are clarifying that when you do secondments, it must be operationally justified. So part of, and the concept of operationally justified is in terms of the Labour Relations Act, where organizations and departments must ensure that as they second employees, they are doing it to the betterment of their own operations and they are not going to undermine the operation of the department from which the employee is being transferred. Chair, in terms of clause 4 of the bill, there's a section in the Principal Act, which is section 7, that talks to the transfer of employees when functions are transferred or assigned. And we know in terms of the Constitution, the President and the Premier can at any time transfer and assign functions across different departments and different ministers and different MECs. And what this provision did was to try and regulate what happens to employees when there is a function transfer. The difficulty with implementing this in the current Act is that there are other pieces of law that already regulate this. So this talks, the current section 7 only refers to the Labour Relations Act, but we know that in terms of function transfers, there is the Public Service Act, there is the Constitution, and there's the Municipal Systems Act. So we are suggesting a repeal of this particular section and a reenactment of Section 14(4) of the Public Service Act. Then in terms of Clause 5, conducting business with the state, this is a provision again that is in Section 8 of the Principal Act. And what we are doing is we are clarifying certain unintended consequences that have arisen as we have implemented this act. So the Principal Act has said no employee may do or conduct business with the state. The first difficulty is that there was no understanding of what was meant by the state. So we've included a definition for organ of state. We've replaced the concept of state with organ of state because we understand from the Constitution that was easier to define. We have also defined when we say no employee may be a director of a company, we have also clarified what is meant by that, and we've linked it to the Companies Act. We have also excluded from the ambit of this particular provision employees who are appointed as a result of their employment in departments on boards of institution and especially public entities. So you will find there is legislation which says, for example, the DPSA must have a representative on a particular public entity board. And those entities then find it difficult to do business with the state or to provide services to the state in lieu of compensation if those employees are on those boards. So we have excluded those particular officials from this provision. We have also, Chair, included an empowering provision which allows the Minister for Public Service and Administration to identify certain transactions that are not construed within the ambit of this provision. One of the simple examples I can give is teachers. As part of the operations of the state, teachers provide or mark exam papers at the end of a matric year and get remunerated for that. But those services are necessary to allow the functioning of the state. So we have allowed for the minister to provide that certain transactions as they become apparent in the provision to be exempted from this. This will just allow that the state is not affected adversely by these provisions. And what the National Assembly did during the discussion of this particular provision is they added in the words which are necessary for the functioning of the state. And that will enable the provision to be utilized to ensure that there's no abuse on those that are exempted from this provision. If we can move to the next slide, please. Chair, in terms of Clause 6 of this amendment bill, this is a new provision which seeks to regulate the conduct of employees or former employees in participating in participating or being employed by service providers following a tender process. What this provision does, it creates a limitation on employees who have been part of a tender process of government where they in any way participate in that process, whether it's setting criteria, evaluating a process, adjudicating, recommending, approving, or in any manner awarding a tender. Those employees are not allowed to become employees of the successful service provider who receives that service or that award. And that this provision seeks to place a 12-month cooling period on that limitation. We've also put in a concomitant process where even a service provider by this provision is prohibited from employing anyone who participated in these processes and from which the service provider has benefited. We've also added we've made this a criminal offense if you contravene this particular provision. We've made it liable to a fine not exceeding R1 million, subject that amount can be adjusted the Minister of Justice. Chair, I think it's important to maybe highlight at this point that there have been considerations since the bill was passed in the National Assembly, that perhaps maybe this fine is not sufficient. Maybe the amount should be linked to the amount of the contract that's awarded. I suspect these are things that the committee will consider and perhaps give us guidance on whether it should be strengthened or whether it should be left as it is. If I can have the next slide, please. Chair, in terms of Clause 7, Section 9 of the Principal Act currently already deals with the disclosure of financial interests. What we have done here is just a redraft exercise, and you will see in Section 8 and 9, it says for purposes of Section 8 and 9, special advisors and those similar positions are part of the definition of employee. We've just simply written the definition in both the provisions. For those who may miss it in the one, it's just to ensure that there's no misinterpretation. So it's just a redrafting exercise. Then, Chair, I'm going to deal with the next few slides holistically. The Principal Act deals with capacity development and the National School of Government. When the Act was passed in 2014, it looked at and it reconfigured the National School of Government from a department, which it currently is, to an institution of higher education. What the current Principal Act says is that the NSG should be established as a higher education institution and should follow the rules of higher education, of a higher education institution, and it should provide services and training to the public service. As we tried to implement those provisions, the difficulties arose from, one, the cost that would be incurred if the National School of Government had to be re-envisaged and reconfigured as an institute of higher education. But the more fundamental one was the fact that the public service doesn't need another higher education institution. The public service needs an institution that is geared towards providing training and education that is developed to deal and address the issues around the public service and the public administration. So as we developed the bill, we reconfigured the National School of Government to retain it as a national department, which means it will not be created as a higher education institution. But we have also enabled the National School of Government to partner with higher education institutions to develop programs and courses, to issue qualifications, part qualifications, all subject to the National Qualifications Act. The provisions and the functions of the National School of Government are more fully set out in the bill itself. In terms of Clause 8, which is capacity development by institutions, one of the things that Section 10.2 of the Principal Act says is that the minister may direct on compulsory training. And what we have done is a redraft of the provisions to ensure that departments make available budgets should compulsory training be identified and directed accordingly. If I can get to the next slide, please. Chair, in respect of Clause 10, it suggests a repeal of Section 12. Section 12 was written primarily to deal with a directive by the minister relating to education in respect of a higher education institution. And because we are repealing or suggesting a different course of a model for the National School of Government, Section 12 then becomes not necessary. In terms of Clause 11, this is a provision that allows the Minister for Public Service and Administration to determine prerequisite education and training or mandatory training. What the Principal Act says is that when the minister determines this training, the minister must consult with Cabinet. We are suggesting that the requirement to consult with Cabinet is an unnecessary process. There are normal consultation processes within government and in the public administration for public consultation, and regulations usually get drafted in that manner. So we are suggesting that that reference to, or that requirement to consult Cabinet be removed. Then, Chair, in terms of Clause 12 sets out a list of areas in Section 16(1) of the Principal Act where the Minister for Public Service and Administration can issue norms and standards. Section 16(1)(a) says the Minister may issue norms and standards on the promotion of values and principles as contemplated in Section 195. However, what Section 16(2) does, Section 16(2) says when the Minister issues norms and standards for particularly the first one, the promotion of values and principles, it has to do that with the concurrence of all executive authorities. That makes regulation making extremely impossible, because if one EA does not agree, then that regulation doesn't get made. So what we are suggesting is that the requirement in 16(2) must be repealed, and any norms and standards set in terms of Section 16 will then be dealt with in terms of Section 18, which is the powers to make regulation. Then in terms of Clause 13, this is a simple amendment. The Act refers to it establishes first the Office of Standards and Compliance, and then in the main sections of Section 17(7), it refers to the office and its members, but there isn't any definition of its members or any reference to its members. So we are suggesting that those words be deleted from the text, as it creates just difficulties in interpretation or reference. The next slide, please. Chair, the next two provisions are quite, have been quite a challenge to get to this point. These two provisions that are set out in Clause 14, it's an inclusion of Section 17(a) and 17(b), which we are proposing. Both these provisions, we've expanded the scope, so we know that the whole Act usually deals with just the 3 spheres of government. It has never expanded to the SOEs. But for purposes of this particular inclusion, we are now bringing the scope of this Act into the public entities. And the reason is that these provisions deal with, one, unjustifiable disparities, but secondly, and more importantly, on the coordination of mandating processes, which deals with remuneration and conditions of service. Chair, we have seen huge disparities in many instances in the public administration, including SOEs. And what Section 17(a) does is it puts in place a process to remove unjustifiable disparities. So what we are saying is that you might have disparities, and we agree that disparities will exist where they are necessary, but where they are not necessary and not justifiable, then those disparities must be removed from the administration. What we are suggesting and what we have proposed in Section 17(a), and this was a provision that was amended during the discussions in the Portfolio Committee and the National Assembly. When we went into the process and when we submitted the bills in 2023 to the National Assembly, we had suggested that the minister may prescribe norms and standards to establish upper limits and remuneration of conditions of service, as well as steps to remove unjustifiable disparities across all institutions, including public entities. But we did not limit it to only the senior management. What the National Assembly process did was that it limited this provision now to members of the senior management. It doesn't include employees who fall within the scope of bargaining council. So I think it's important to note that for purposes of 17A, we are dealing with the higher echelons of all of these institutions to ensure that we have minimum upper limits, etc. Then in terms of Section 17B, which is your mandating processes, we have developed a provision that requires or that places certain requirements on employers to consult the Minister of Finance and the Minister for Public Service and Administration when they make any determination on conditions of service and remuneration that affect employees. And the big reason to do this is to ensure that whatever happens in whichever institution and whichever arm of the spheres of government, that there isn't instability with the fiscal framework. So the idea is to ensure that our fiscal framework remains sustainable from a wage perspective as well as from a conditions of service perspective. So the proposal in 17B remains the same for the public service employees, where there is a committee of ministers that must determine and mandate and approve conditions of service before it's approved in any bargaining council, and that continues. For the public entities and local government, there must be consultation with the Minister of Finance and the Minister of Public Service and Administration. And lastly, Chair, in terms of, or maybe not lastly, but in terms of clause 15, it's a process to draft or to issue regulations, and this is already in the Act. Currently, it requires the concurrence of the Minister of COCTA, the Minister of Finance, and SALGA. What we are proposing is an alignment with the Municipal Systems Act, which requires that SALGA needs only to be consulted, and there doesn't need to be agreement with SALGA on regulations. Chair, I think it's important at this stage to also note that when we had drafted the bill, we had made reference to the minister responsible for public entities. We know with the recent configuration of government, we no longer have a minister responsible for public entities, which is one minister. We have many ministers who are responsible for public entities, so there might need to be a redrafting of that particular provision to consult at least those ministers responsible for those public entities. The next slide, please. I think I'm almost at the end. Chair, the laws that are repealed are in the schedule of the amendment bill. Like we discussed earlier, our proposal is that Section 14 of the Public Service Act in respect of transfers must be retained in the Public Service Act. And the PAMA will have the provisions that we have proposed already. And then there is a proposal to substitute Section 22A of the Public Service Act. And this is simply to deal with the new mandating arrangements that we are creating in terms of the Act. Chair, and this is the short title. I'm going to stop there. Thank you so much.
Thank you very much, and I really do appreciate the two presentations. I know they can be quite lengthy. Okay, let's see. Have we got any questions on this section? I'm looking for hands. If you've got any questions, ask now. Okay, I'm not seeing anyone. Going. Last opportunity. Okay, no questions. So you get all easy on this round, I must say. Well done. Oh, wait, there we go. Honourable Bryant, you have got your hand up just in time. Please, go ahead.
Thanks, Chair. Sorry, it's just a quick one and it might be a silly question, so excuse me if it is. But just in terms of the approach to municipalities, is a distinction drawn between, and I'm assuming there would be, but is there a distinction drawn between how the legislation is written in terms of the different scales of municipalities, i.e. the district municipalities versus the metro municipalities? Because obviously, you know, the challenges are different, and in particular in the rural areas, they are far more significant challenges, particularly when it comes to staffing expertise, etc. I just wonder if that, has formed part of the consideration when it comes to, to these amendments.
I'd actually like to add on to that before you answer, because I had the same thought. How would that affect the finances of the municipalities concerned? Because there are a number of municipalities, particularly rural municipalities across the country, that have enormous financial problems for various reasons. And talking about a single public service and talking about conditions of work and parity and salaries and everything, would one potentially end up in a situation where it would hamstring more financially inept municipalities, to use the term, versus municipalities that are perhaps better at running their finances? Thanks.
Chair, if I may come in.
Please.
Thank you for the question. I think this has been a really difficult terrain to maneuver, simply because you have organized local government at a municipal level who has constitutional as well as legislative authority. You have municipalities which have their independence, and you have the public service which operates differently. So in drafting the provision, one of the concerns that were raised was the encroachment of this piece of legislation into any of those specific or possible parameters, especially from a SALGA perspective. So the way we've drafted it is that all of the provisions and all of the requirements under which conditions of service, remuneration, and financial sustainability for municipalities in terms of the Municipal Finance Act, all of those stay in place. What we have done is we've put in a different or another layer of checking. And that layer of checking that we've put in is that when it comes to committing municipalities or any other government institution, whether it's at a national or provincial sphere, when you are committing finances, and this also includes SOEs, the minute you are committing finances to conditions of service and remuneration of employees, you must at the very least consult the Minister of Finance and the Minister of Public Service and Administration. The idea is that when you do that consultation, there should immediately be red flags if it's necessary in terms of what the outcomes would be from a compensation perspective. So we're looking at it very much from the lens of the people that are employed in the public administration and the SOEs. So the idea is to then sort of centralize it, but not take away powers. So it was a very fine line, and therefore the consultation process is not that the Minister of Finance must agree. We tried that; it didn't go well. So the bill in its current form says you must at least consult, and we know that when you consult, you can get challenged if you don't take the consultation seriously. Chair, the other issue that we've raised, and precisely to deal with the issues that face municipalities and even SOEs, is that there isn't a framework within which negotiations or the determination of conditions of service is done. So things like affordability, sustainability, those are not things that currently are determined at some central point with the Minister of Finance. What the bill does do, it makes provision for the Minister of Finance and the Minister for Public Service and Administration to at least develop a framework that all institutions must adhere to ensure that they remain within that fiscal framework that we talk about. I hope I've answered. Thank you, Chair.
Thanks very much. Are there any follow-ups or other questions? Other hands? Honourable Bryant, are you happy with the answer you got?
Yes, Chair. I can understand it's a complicated and complex matter to deal with, and I suppose we're not going to resolve it in this meeting because it is really more of a Q&A. But thank you for the feedback. Thanks.
Thanks very much. Okay, if there are no further questions on this, then I'm just going to ask up permanent delegates in the NCOP if they want to add anything at this particular point.
Well, thank you, Chair. Am I audible?
Yes, you are.
Now, I just wanted to say on the Public Service Amendment Bill, this bill really provides provision for the devolution of administrative powers to the heads of departments. To give them the executive functions to do that. And also, this bill is very much a step very much in the right direction of transparency and accountability, to make sure that it's safeguarded. What is good about this bill is going to really root out corruption and professionalize, like I said previously, with the public services, and will definitely put an end to cadre deployment. And then his comments on the public administration management bill. This is also, again, it's going to improve service delivery with human resources, governance, and with all three spheres of government. And it's also going to provide better transfer or secondment between employees. And then will also remove very much unjustifiable disparities across the state institutions. And the last comment on the administration is that it will definitely, we must definitely monitor this bill when it's implemented, because it will definitely keep an effect to better public service. So those are just the additional comments that I wanted to add on the two different bills. Thank you, Chair.
Thanks. You weren't that clear, but I think we managed to follow what you were saying there. Any other comments from anybody at this point? Anyone on the committee has got anything to say in terms of, not a question, but a comment? Okay, I'm not seeing anyone. I just want to mention that we haven't yet received the program from the NCOP for the negotiating and final mandates on these bills. So we're going to have to wait on that. I mean, obviously keep in touch with our permanent delegate to keep us in the loop. So it's still a long way to go. Does anybody want to say anything about time periods or timing issues?
Yeah, I think information that I've got from the committee secretary was that they're looking at the end of March for this bill. So there is still a bit of time to go. We're only getting the briefing on the principal acts this Tuesday. So I think thereafter we'll start doing the negotiating mandates will start going up.
Okay, great. All right, so there is still a bit of time, so everyone can familiarize themselves with everything before we really kick off the process in this regard. If nobody's got anything else to say on this particular point, I just want to say thank you very, very much to the department and to the Deputy Minister for being here and for this briefing. Are there any closing comments from your side? Deputy Minister or the department, DG?
Chair, I think our DG was disconnected, and I think our DM apologized, but we are comfortable from our side. Thank you so much.
We really appreciate that. I think when we get to the hearings, we will be leaning on you as much as we can for you to come and do those briefings, because I think it's going to be important that we actually do the public participation thoroughly. But yes, we'll see you again in the new year then, and we'll keep in touch. We'll keep in touch with our delegates as well. So thank you very, very much. And I think that the officials of the department can now be excused, so we can just continue with a bit of housekeeping. But thank you very, very much.
Thank you so much, Chair and members.
Thank you.
Thanks, then. Bye-bye. I can just ask the committee to stay. We've just got a couple of issues we need to attend to. Okay, I think it is. Okay, what we need to do now, everyone, is we just need to consider and adopt the draft committee meeting minutes from the 8th of November. There we are.
Chair, with your permission, we'll excuse ourselves in the NCOP.
Oh, come on, I'm sure you don't have anything better to do on a Friday afternoon.
I'm going to try and beat the traffic out of Parliament. Cheers.
Probably a bit late. Bye-bye, everyone. Thanks, guys.
Bye.
Thanks, then.
Thank
Okay,
you.
right.
Bye-bye.
Here we've got the fighting of those minutes from the 8th of November. We can just check through those. And then if we can have a proposer and a seconder, unless there is an issue that someone wants to raise.
I propose, Chairperson.
Thank you very much, Member Bryant. Seconder?
Second, Chair.
Okay, thank you very much, Member Kazafalanda. Just in terms of this going forward, we do have a meeting next week, but that will be dealing with budget issues. And then our next meeting will be, I think our procedure officer said, the 31st of January. So everybody has quite a lot of time to read and digest everything that we have been dealing with, yeah? Now, in terms of resolutions, has anybody got any resolutions coming out of this meeting today? I think as we can see that we're actually doing rather well time-wise. I would like to propose that we just, in the new year, revisit progress in this regard and keep in touch with the NCOP to see where we are, so that we're in a position to actually plan going forward. Has anyone got any issue with that or wants to add to that? Alternatively, second that?
I second, Chair.
Thank you very much. Right, I think that is it. Procedure officer, is there anything else we need to raise at this point?
No, Chairperson, everything's covered. Thank you.
All right, thank you, everybody. Thank you for sitting through a Friday afternoon. I really appreciate it. And have a good weekend. The meeting is adjourned.
Thank you, Chair. You too.
Thank you,
Bye-bye.
Chairperson.
Bye-bye.